Hello, dear viewers. Today I'm going to be talking about the Gyanvapi Mosque case and the recent order by the Supreme Court on the case. Let's begin. Welcome to Global Nationalism. I am a global nationalist. I support nationalism in my country, India, and in all countries around the globe. Today I'm going to be talking about Indian nationalism with respect to current events. Today, the case I'm going to be focusing on the Gyanvapi Mosque case, where Hindus believe that it is a mosque built on top of a destroyed Hindu temple, specifically the Kashi Vishwanath temple, and Muslims believe it is originally a mosque, always has been a mosque, and this case has been going on since 1991. I want to talk about the history of the case and the recent order from the Supreme Court, which affirmed the decisions of the lower courts to allow the Archaeological Survey of India to conduct a survey and examination of the Gyanvapi Mosque to find out if there is any other structure on which it is built on. Let's get started. The first petition was filed in 1991. The first petition of the case was filed by Swayambhu Jyotirlinga Bhagwan Vishweshwar in Varanasi court in 1991. Three demands were expressed by the petitioner. One, declaring the entire Gyanvapi Mosque complex as a part of the Kashi temple, removal of Muslims from the complex area, and demolition of the mosque. Of these, I agree with I first of all don't actually have a say yet because there has not been judicially proven that it is was a temple. But if it indeed was, then I do think the mosque should be demolished and the Gyanvapi complex should be a part of the Kashi temple. However, I do not agree that Muslims should be removed from complex area. They can also be part of the complex area as long as they're not attacking the temple in any way. Just like Hindus can go inside a mosque or a church legal, there's no law against that. Unless once the temple is built, there's a rule saying that Muslims are not allowed and the temple is privately owned. Then I agree with that, but not by a law from the government. In 1998, another case was filed by Anjuman Intezamiya Masjid Committee, which approached the Allahabad High Court, asserting that the dispute between the temple and the mosque could not be decided by a civil court as it was not permissible by the law. As a result, the High Court stayed the proceedings for 22 years. Yeah, the Indian judiciary can do that. They're very happy to delay stuff. So this is the Muslim side. They said that this dispute cannot be decided by civil court, and the Allahabad High Court agreed with them and stayed the proceedings that were started in Varanasi Court in 1991. In 2019, the next friend of the first petitioner in 1991, Vijay Shankar Rastogi, filed a plea in the Varanasi court demanding an archaeological survey of the disputed area. So this is just a demand for an archaeological survey, not a demand for changing the nature of the place of the mosque, not for destroying it or rebuilding it, a temple upon it, just to find out what the structure actually is via a survey. In 2020, this plea further encouraged the Anjuman Intezamiya Masjid Committee to oppose the petition seeking an ASI survey of the entire Gyanvapi complex. In the same year, the petitioner approached the lower court for a resumption of the hearing of 1991 petition. Yeah, so the petitioner, I guess, is Shankar Rastogi. He approached the lower court for resumption of the hearing of 1991 petition, and he wanted, but so that's a different hearing from the one he filed in 2019. And the Anjuman Intizamiya Masjid Committee opposed the petition seeking an SI survey. In March 2021, the Places of Worship Act 1991 was taken up by a bench in the Supreme Court led by the former Chief Justice S.A. Bobde to examine its substantiality. The case in August 2021, five female devotees filed a petition in the Varanasi court seeking permission to worship deities in the complex because they believe that there were some evidence that those deities have been worshipped in the past in the mosque, and therefore they believe that they have a right to do so. The court did not give any judgment on that matter. In September 2021, in the Allahabad High Court said it was announced that the court should wait for further judgment in the already proceeding case of the matter. So they were not going to make any judgment on the matter. The lower courts had given theirs. The court below should not have proceeded and decided the application filed by the plaintiffs in the original suit for Survey by Archaeological Survey of India. And they said that the court below should wait for the verdict in petitions pending before this court and not proceed further in the matter till the time a judgment is delivered. Okay, I misunderstood that. They're talking about the lower court, that they should not make a judgment in the matter before other cases have been adjudged. On the basis of the petition filed in August 2021, the Varanasi court appointed an advocate commissioner and ordered a videography survey of the complex. The order was again challenged by the Masjid Committee in the Allahabad High Court, which upheld the order of the lower court. This time, the party also filed a special leave petition in the Supreme Court in May 14th, 19 to 19th. The survey resumed again and was conducted for 2 days. All the survey findings were submitted in a report to the court. In May 20th, the case proceedings were transferred to a district judge. SC subsequently said it would intervene only after the district judge had decided on the preliminary aspects of the case. And May 26th, the district court began hearing the maintainability petition of the case. However, the argument given by the petitioner's side, that of the Masjid Committee, remained incomplete till that date. In October 2022, the Varanasi District Court rejected the plea for carbon dating of the Shivling, claiming to have been found in the Gyanvapi Mosque. I disagree with this judgment or order, whichever it was, because that there is an object in the mosque that does look like a shivling but may not be, and if it predates the mosque, then that is evidence that the mosque was built on top of a temple, so it would be necessary to carbon date it. The Supreme Court in November 2022, the Supreme Court agreed to set up a bench to hear the case. In May 2023, on 12th May, the Allahabad High Court ordered the determination of the age of the Shivling using modern technology. So this is a uh, reversal of the Varanasi District Court's judgment. In May 19th, on May 19th, Supreme Court defers scientific survey to determine the age of Shivling. In July 2023, on July 21st, Varanasi District Court directs the ASI to conduct a search, including excavations wherever necessary, to determine if the mosque was built at a place where a temple existed earlier. The SC holds ASI survey at premises till 5 p.m. on July 26th, asks the High Court to hear the mosque panel's plea. The Allahabad High Court on July 27 reserved its order and extended the stay on the ASI's survey until August 3rd. On August 3rd, Allahabad High Court allows scientific survey of Gyanvapi premises in the interest of justice. Anjuman in August 3rd, the Masjid Committee moves Supreme Court challenging the Allahabad High Court order. On 4th August, Supreme Court refused to stay the ASI survey to Gyanvapi Mosque at Varanasi, except the Wuzu Khana area where shivling was claimed to have been found last year. So here, the SC has declined to stay on the ASI surveys, but said that there shall be no excavation. Let me go into the details of the order of the SC. They said that basically they disposed of a petition filed by a Masjid Committee challenged the Allahabad High Court order which permitted the ASI survey. They said that it is clarified on behalf of the ASI by Solicitor General of India, Mr. Tushar Mehta, that as a matter of fact, the entire survey will be completed without any excavation of the site and without causing any destruction to the structure. Evidentiary value of the scientific commission is open to be tested in the suit and is open to objections, including cross-examination. Hence, the report of the commissioner by itself does not amount to a determination of the matters in dispute. And both the High Court and the Varanasi District Court, which ordered the ASI survey on July 21st, had held earlier that the suit filed by some Hindu devotees to assert their right to worship some deities within the mosque precinct was not barred by the Place of Worship Special Provisions Act 1991. The suit was solely for the right to worship and not to seek any declaration that the building was temple. In a bizarre contradiction to this stand, the worshippers filed applications seeking a scientific survey by archaeologists to ascertain whether the Gyanvapi Mosque was built on the demolished structure of a Hindu temple. Now, this seems can be confusing. Basically, they want to worship a mosque, but that for and then in their plaint to the court, they did not say that they wanted the building declared as a temple. So allowing them to do so, this was not an unconstitutional demand or an unlawful demand. And however, later the worshippers filed applications seeking a scientific survey by archaeologists to ascertain whether the Gyanvapi Mosque was built on the demolished structure of a Hindu temple. The district, and so they wanted to. So this can see as if they're moving goalposts, but this is simply a application to the archaeologists and isn't related to the what the court is saying. The court is allowing them to worship, and they're speaking to the archaeologists to ascertain the character of the mosque or the building. So two different things. It's not a contradiction exactly. They never said that they were not going to find out whether it was built on top of a temple. The district court's order merely said that a scientific report would bring out the true facts about this case and help it arrive at a just and reasonable conclusion. And for the Supreme Court, that was enough reason to support them. The plea for a survey and intent to rake up the question of an earlier structure of the mosque indicated design to create conditions for seeking alteration to its status. That may be its motive, but that doesn't deny the fact that They can make a survey of the building. That's not illegal. Here we can see this in the place of worship act itself. It is an act to prohibit the conversion of any place of worship and to provide for the maintenance of the religious character of any place of worship as it existed on the 15th day of August 1947, and for matters connected therewith or incidental thereto. Now, how does it define conversion? It means includes alteration or change of whatever nature. Section 3 says that a bar of conversion of places of worship, no person shall convert any place of worship of any religious denomination or any section thereof into a place of worship of a different section of the same religious denomination or of a different religious denomination or any section thereof. I think that this is a good order by Supreme Court that we need the Archaeological Survey of India to properly understand what this structure truly is in character. I don't think that simply finding out if it was built on top of a temple changes the character of the structure as of 15th August 1947, because we're looking at what was there before what the structure was built. Even if there was built on top of a different religious structure, it doesn't change the fact that in independent India it is a mosque and it cannot be changed as per the Place of Worship Act. Now, what I think the BJP government should do in the center is to repeal the Place of Religious Worship Act, or at least amend it, saying that nobody can destroy a religious place of worship on their own, and only a government can do that if it can prove that another religious structure was destroyed in order for this one to be built. The lawyer for the Muslims in the Supreme Court said that this is opening up old wounds and not necessary. Whether it opens up old wounds or not is not for the court to consider. That is something that the executive should be concerned with. The judiciary only has to focus on the lawfulness of the demand, and the demand of the Hindus is lawful. So I agree with this order. And yeah, that's all I wanted to say. Please share your thoughts on the video in the comment section. If you want to see other videos about Indian nationalism with respect to current events, click here. If you want to see my previous video, click here. If you want to see the sources I use for this video, click the links in the description below. Thank you for watching. Goodbye.